I was asked to provide some history, a short history about how we got to where we are today. And so I want to start back in mid-1950s, late 1950s, is when the state legislature put the word incumbent on the judicial ballot. You won't find it in any other election, but you will find it in judicial elections. Shortly after that, sometime in the early 1960s, the Minnesota Supreme Court started creating a whole bunch of rules regarding judicial elections, and they said that if you violated the rules, it was unethical conduct. So one of their rules was that it was unethical for judicial candidates to state their views on a legal or political issue. Now, what you were supposed to talk about, I don't know, when you're running for this office, but you couldn't talk about legal or political issues. Another rule was that you couldn't personally solicit campaign funds. And they had rules and rules and rules. Now, I want you to understand that none of those rules would have made any sense, and I doubt very much the court would have ever adopted any of those rules, except for the fact that that word incumbent was on the ballot. And with that word incumbent on the ballot, the less information that gets out to the voters, the more powerful that word is in influencing the vote. So, from the judge's perspective, these rules worked very well. And in fact, in the last 50 years, not one Minnesota Supreme Court justice incumbent has lost an election. And since the Court of Appeals was created, not one incumbent judge has lost an election. In 1996, I decided I wanted to run for the office of the Minnesota Supreme Court, and I was concerned about a series of criminal cases. And I thought if I could tell everyone about those cases, just tell them about those cases, that they would be very upset with what the Minnesota Supreme Court had done, and that I could perhaps win. But I ran into these rules that said you couldn't attend or you couldn't state your views, so I didn't state my views. I only stated what the dissenting judges said. And this created quite a stir in the legal community, and I also started doing something somebody hadn't done in many years. I started going to political conventions. Went to numerous political conventions of every political party you can imagine. Word of this filtered to the Minnesota Supreme Court. The next thing I knew, I had ethics complaints filed against me for attending political party gatherings, and that stopped me for a period of time until I finally got a ruling saying I could go ahead and attend, and then I went right back to attending and speaking. Again, not stating my views, simply stating the views of what dissenting judges had said. In January of 1998, the Minnesota Supreme Court created a new rule. The new rule was that judicial candidates could not attend and speak at political party gatherings. So, in March of '98, the Republican Party joined me in a lawsuit. And that lawsuit later became known as the Republican Party of Minnesota versus White, or sometimes called White 1. It went all the way up to the U.S. Supreme Court. And in 2002, the U.S. Supreme Court decided that a lot of these, at least one of the rules that they took under consideration was unconstitutional. And they struck down the rule that prohibited judicial candidates from stating their views on legal or political issues. All the other issues we had raised in the case were then sent back to the 8th Circuit Court of Appeals for decision, and we got a favorable decision from the 8th Circuit Court of Appeals in 2006. That case is called White 2. It's also called the Republican Party of Minnesota versus White, so you don't want to get confused. In that case, the 8th Circuit said that struck down the rules that prohibited judicial candidates from attending and speaking at political party gatherings, identifying themselves as members of a political party, personally soliciting campaign funds. Well, I thought I'd change this system, but I was wrong, because the Minnesota Supreme Court created a new rule, or rules. One of the new rules was that judicial candidates can personally solicit campaign funds, but only if there are 20 or more people in your audience. So now you've got to count how many people are out there. And there's always the question about, what about the waitress who walks through? Can I count her or not? And then sometimes I've often thought, maybe what I really need is you really need a candidate and 19 surrogates to follow the candidate along, so that you can actually ask that one person you want for money. Arnie Carlson once ran for office with a group of people called Arnie's Army, where he basically did something similar to that. So we started a new lawsuit challenging that rule. I had a favorable decision in front of a 3-judge panel of the 8th Circuit Court of Appeals last summer. I'm not exactly sure the date. Shortly thereafter, the other side asked for en banc review, which means it would go to the entire 8th Circuit, which consists of, 16 to 20 judges. It is now, we had oral argument in front of the entire 8th Circuit January of this year. We don't have a decision yet. So that is still pending. Now, Governor Quee is right. He and I agree on one thing absolutely positively, which is judicial elections in this state do not work. Anyone who tries to tell you, the only people who will tell you they work are the judges. That's because they get to win over and over and over. And they think that means it works. It doesn't work quite conclusively, because when you go to vote and when 99% of the people go to vote, they have no idea who the candidates are or why they should vote for them. That has to be evidence of a system that isn't working. So what happens? What happens is there's that word incumbent on the ballot. And if you look at these elections over and over and over again, about 40 to 45% of the people vote against the incumbent, and about 55 to 60% of the people vote for the incumbent. And this happens over and over and over again, and that is why we've got this history of 50 years, no judge on the Minnesota Supreme Court being defeated. I think that this is horrible. I think it's horrible because what we've created is a system of government that is unaccountable to the public. Somehow you have to have accountability. Somehow when we have a bad judge, we need to get rid of him. Now we haven't had a working election system for the better part of 40 or 50 years, at least with regard to judicial elections. That means, and literally over 94% of all judges are initially appointed to their positions by the governor. And that means that the governor is perhaps appointing friends, relatives, cronies. Doesn't mean they're good judges. Maybe they were excellent lawyers, but a lot of excellent lawyers aren't good judges either. We need a way to get rid of the bad judges. I'll agree that in Minnesota we have excellent judges. We have a whole bunch of mediocre judges. And we've got some really bad judges. And we need a way to get rid of them. We need an election system that works. I propose what we need is to get rid of the word incumbent. There's a bill in front of the legislature right now to accomplish that. Governor Quee and his people have a bill in front of the legislature, I believe, as well.
Not yet.
Not yet? Soon, though.
Before the next session, we'll take it up.
Okay. It was there the last session. And that bill would create a what they call a retention election system, where you can't vote anybody into office, you can only vote them out of office, and then the governor appoints somebody again. I would like to clarify that I have actually one thing about what the governor said, and that is I have nothing against retention elections, as long as nobody has filed for that office. What I'm saying is that we should have competitive elections in every case we can, and if there isn't anyone running against that judge to give the voters a choice, then yes, let's have a retention election for that position, so that the voters still have that opportunity. And with that, I think I've covered pretty much the history, and I'll turn it over to the